In other words, shut up.
Well,
Judge, can I just,
hopefully I put it a little kinder than that.
yeah.
Calling pages 10 and 11, case 862-259, Shannon Ruth versus Nickolas Carter.
Good morning, Your Honor. John Kawai for Plaintiff AR.
Good morning.
Morning, Judge. Dale Hayes on behalf of Nickolas Carter.
Good morning, Your Honor. Mark Boscovich on behalf of Shannon Ruth.
I didn't get your name. Sorry, say that again.
Mark Boscovich.
Okay. Good morning.
And good morning, Your Honor. Alan Greenberg for counter defendants Melissa Schumann and Jerome Schumann in the other consolidated case with the Ruth case.
Good morning. Long time no see. All right. So I've reviewed plaintiff / counter defendant AR's motion to dismiss, motion to strike, defendant counterclaimant Nickolas Carter's counterclaim pursuant to NRCP 12B5 and 12F. Carter's opposition, plaintiff's motion to remove from business court, the opposition to that motion to remove. I did not see, so I guess this question for moving parties, maybe were there replies filed?
No, Your Honor.
Okay. Well, that makes me feel better because
And I don't know, Your Honor, if Your Honor has it on for hearing. This morning, there was an ex parte application to seal filed by defendant.
Okay, that's in chambers. Does anybody oppose that motion to seal would be a question, I guess.
John Kawai for Plaintiff AR, no opposition.
Okay, so that motion seals granted. Go ahead and prepare that order. Let's see. Well, I guess we should probably do the jurisdictional one first, which would be plaintiff's motion to remove from business court, because if this is granted, then I'm not getting to the 12B5 and 12F motion. I am inclined to deny this motion to remove, but welcome arguments beginning with plaintiff's counsel.
Yes, Your Honor. Clearly, Rule 1.61 does set forth what are business matters, and that can include claims arising from business torts. However, I believe that it is clear from our motion to remove, as well as the motion to dismiss, which Your Honor has already reviewed, that the predominant legal issues are centered on those of personal injury, and therefore it would be excluded under subsection B of Rule 1.61. Simply, every single counterclaim logically depends on the core consideration of whether sexual battery was committed.
Thank you. Oh,
and having
sat
through this morning's docket, this would appear to be an outlier, but
thank you. Any opposition?
Judge, I don't know how much you want me to argue given your inclination, but in his motion, counsel ignored one of the categories of business court matters, which is business torts, which clearly intentional interference claims are. It's not some type of secondary claim. It's paramount to this lawsuit. Just the same way the alleged sexual assault is paramount to his client's claims, that's the epicenter of the extortion and in the business torts on our end of it. And I think what counsel's doing is he's overemphasizing his client's claims and ignoring the counterclaim. And we've submitted evidence already, Judge, of substantial damages connected to this extortion, the conspiracy. This isn't just a personal injury claim. In fact, most of our counterclaims have to do with business torts, intentional interference, civil conspiracy. So I'll submit on that unless you have any specific questions, but this matter should clearly be in business court. It's been in business court for over a year. None of the other attorneys moved to have it removed that have been involved in this lawsuit. And we would submit on that, Judge.
Thank you. Any rebuttal?
Yes, Your Honor. When plaintiff AR brought her claim, there was no, it's against an individual. It's not, against an LLC. I don't quite know if Mr. Carter is intending to make his personal finances at issue in the case, but there's no business claiming business losses in this matter.
Thank you very much. So the court denies plaintiff/counter defendant AR's motion to remove from business court. The counterclaims do involve quote unquote business torts, and therefore the case as a whole falls within the rule regarding the jurisdiction of our business court. Mr. Hayes, you'll prepare that order, submit it to Mr. Kawai and everyone else on the other side for review and approval. For better or worse, I'm keeping the case. Okay, so plaintiff's motion to dismiss and a motion to strike. I'll tell you, I'm inclined to deny it without prejudice. Under Nevada law, at this early stage, on the motion to dismiss as well as the motion to strike, I'm bound to accept all facts as pleaded and the counterclaim is true. Nevada's a notice pleading state. Certainly not addressing any of the merits of the counterclaims, but I think they do fall within the Nevada notice pleading and 12B5 and 12F confines, and therefore I'd be inclined to deny it without prejudice, but welcome, Mark.
Yes, Your Honor. Thank you. So we agree that the court's job is to take the facts alleged as true, but I think what legally follows from the facts as set forth in the counterclaim makes the claims basically impossible. You can't admit to engaging in sexual conduct with a 15-year-old and then claim that it's defamatory when she says that she was the victim of statutory rape, for example. And that forms the basis of the defamation claim. There's questions as to whether there is privilege or justification on her behalf in speaking out about the same issues. So yes, we can accept the factual allegations as true, but the legal consequences of that are not open to debate.
Thank you very much. Any opposition?
Just briefly, Your Honor, in light of your inclination, I would like to reserve a little time to rebut, given that no reply was filed. But how I respond to that, judges, we're dealing with this every time we're in front of you. My client did not admit to sexually assaulting an underage individual. He admitted to consensual sex with a person whom he believed to be 18. They haven't even proved his underage yet, Your Honor, at the time, which is another factual issue. But of course, I'm sure, as Your Honor knows, the truth to whether she's telling the truth or not, the truth as a defense of defamation is always a question of fact, totally improper for Rule 12b-5 consideration, Your Honor. And what counsel is trying to do, in essence, is use a criminal statute from Florida to not only resolve, but dispositively resolve the germane issues of a civil lawsuit in Nevada. And that's wholly inappropriate to say, this isn't a criminal prosecution for stat rape, Your Honor. This is a civil lawsuit for assault with a number of counterclaims. And I wanted to bring this case to Your Honor's attention just because we keep dealing with this. Oh, he admitted the case is over. He didn't admit to anything. He admitted to consensual sex, which she, in her own sworn statements to police, she said it was consensual. But
Well, I did, to reiterate, I did review the briefs, quite carefully, so, yeah.
In other words, shut up.
Well,
Judge, can I just?
hopefully I put it a little kinder than that.
Yeah, can I just leave you with this case? Because I kind of want to put an end to this every time we're in front of you with this. He admitted and the case is over. A local criminal defense attorney in a criminal prosecution here in Nevada tried the same tactic, and he tried it in a case called Honia v. State, 136 Nevada, 285, Judge. And what that case involved was an adult who had sexual relationship with the underage girl between the ages of 11 and 15. So it was a 4-year-long relationship. The state opted to charge the man under the general sex assault statute versus the Nevada statute.
Let me pause you. Where am I looking for that in your brief?
It's not in the brief. It's in. I cited to the California case in my footnote. I found it after, but I did make this argument. It's a supplemental brief. But basically, what the case holds, Your Honor, and I'll just quote it. We reject the state's argument that the age of consent from a wholly separate statute could be assigned to the sex assault statute. So what they were saying was, I don't care if she's 15. This isn't a stat rape prosecution. This is a sex assault. They wouldn't even let it happen in a criminal prosecution within Nevada. Both of those are related Nevada statutes, Judge. And so what counsel is trying to do is essentially 15 degrees removed from that, because he's trying to use a Florida statute to resolve a factual issue in Nevada. And I know that I'm getting into facts here. I just wanted to bring it up because even the procedural motion to remove from business court, we have to deal with it. But unless you have any questions, Your Honor, I'll submit on that. And like you said, these are all questions of fact, as I quoted in my opposition. And that's all I have, Judge.
Thank you. Mr. Kawai.
Yes, Your Honor, the admission is literally written into the counterclaim as well as the answer. In the counterclaim, it's paragraph 193, and it's absolutely, whether or not that conduct falls under a statute of statutory rape versus sexual assault is not the point. The point is that given that there is no way that a minor could have given legally consent, we have to accept all the legal consequences from that admission.
Thank you very much. So I'm going to stick with my initial inclination, deny the motion to dismiss and strike without prejudice for the reasons I stated earlier. Under the standard here, I have to accept all facts as pleaded. The counterclaim is true. Nevada is a notice pleading state. The standards under 12B5 and 12F are, if not exactly the same, substantially similar. And the counterclaim, again, this is all without prejudice, but as it is pleaded, the counterclaim does state claims under Nevada law for which relief may be granted, again without prejudice as to further motion practice and or trial on the merits. So Mr. Hayes, you'll prepare that order, put the reasons in there, submit it to Mr. Kawai and everyone else for review and approval.
Thanks, Judge.
Thank you. Thank you.
Thank you, Your Honor.
Thank you. Good job.